I'm Cathryn Cluver, the Executive Director of the Future of Diplomacy Project. I'm joined today by Justice Richard Goldstone, former prosecutor for the United Nations Tribunals on Yugoslavia and Rwanda, the former Justice of the Constitutional Court of South Africa, and we're here for a conversation in diplomacy. Welcome, first of all.
Thank you very much.
Back to Cambridge. I wanted to talk to you about recent events and reflecting on recent events, and then not so recent events. So on April 6th, we marked the 20th anniversary of the Bosnian War and the siege on Sarajevo. And you served on the International War Crimes Tribunal right in the center of, or while the Dayton Peace Accords were being negotiated. From your perspective, how did the existence of the court affect the diplomatic resolution and vice versa?
Well, it complicated the diplomatic work in some respects, because the diplomats, the politicians, like to have as simple a world as possible, and having a war crimes tribunal investigate war crimes, serious war crimes, including genocide and crimes against humanity and so forth, created a tension, because when it came to it was in the middle of the war that we began, and there were intense negotiations to bring that war to an end, and it was thought by some of the Western politicians, particularly from the United States, that the fear of prosecution would be an incentive for leaders such as Milosevic or Karadzic not to agree to end the war, because it would bring them to trial in The Hague. So there was that diplomatic problem. As it turned out, it wasn't a fear that really materialized. In fact, the very contrary took place, because the indictment of Karadzic enabled Richard Holbrooke to call the meeting at Dayton, Ohio, that effectively put an end to the war, and the guns have remained silent since then.
Is that something that you, from your vantage point, saw coming? I mean, did you perceive it always as the legal remit, as a containing environment for
not really. My job was to prosecute, to investigate and bring out indictments. The fact that the indictment of Karadzic had a good outcome was really luck or happenstance more than design. I wish I could claim great prescience and foresight, but obviously that's not the way things work.
So that gets me sort of to my second question, in terms of how do you feel, or what do you think that diplomatic processes, their role in international criminal justice? So the whole Karadzic piece, the carrot and stick behind it is, of course, you deliver the indicted war criminal. Then come the carrots, EU membership, whatever it may be, and we've seen this play out in various other ways. Most recently in Libya, how do we deal with that? So, generally, from the specific to the general, perhaps given your experience, that interplay.
Right. Well, it must be recognized at the outset that international criminal justice is all about politics. It requires political will to set up the institutions of international justice, and it takes even more political will to see that they succeed. This was, of course, the important role that the United States played with regard particularly to the Yugoslavia Tribunal, but also to Rwanda, that without the United States exercising its resources, diplomatic, economic, and so forth, without that, the two tribunals would have been a failure. No arrests would have been made, and they would have gone out of existence and been written off by history as a horribly failed experiment. So it was very much the United States diplomacy that brought these institutions into being and ensured that they succeeded. From my end as Chief Prosecutor, the diplomacy was also crucial, because when I arrived in The Hague on the 15th of August of 1994, the international community, and particularly the media, had written off the Yugoslavia Tribunal as a flop. There were accusations that it was intended not to succeed by the great powers, that it was referred to disparagingly as the fig leaf created to hide the embarrassment of the West for not using military force to protect the civilians who were being slaughtered in the Bosnian wars between 1991 and 1993. And it was really diplomacy and particularly galvanizing the leading Western nations to give us financial aid, which we needed, but importantly to give us political backing in order to ensure that our work could succeed.
So we talked earlier about an ideal world in which international justice played a larger role, and you talked about that a few hours ago. I wonder if I could get you to reflect on that as well, but particularly since you've just mentioned the role of the United States, not a signatory or and supporter of the ICC, but still, because of its immense power, people argue that it's in decline, but its immense leadership capacity, its immense convening capacity, power on the one hand, and institutions of justice on the other hand, perhaps, is, for instance, in the United States case, is that a convenient excuse for it to stay out of that kind of structure because it still has harnessing capacity to support that kind of work?
Well, the United States today is supporting the International Criminal Court, not to the extent of ratifying the Rome Treaty, but the United States has always had this conflict. Virtually all powerful nations don't like being judged by outside institutions. I think that's a generalization that holds up, and it's not coincidental that the four major powers who have not ratified the Rome Treaty, together with the United States, are Russia, China, and India. For the undemocratic nations, for China and Russia in particular, they're not conflicted. They just don't like international justice. They don't want to be judged by any international court. The United States is much more nuanced, because the United States fully supports international justice. The United States, and I guess the overwhelming majority of American citizens, don't like war criminals and don't believe that there should be impunity for war criminals. So the United States thinks that international criminal justice is a great idea as long as it doesn't involve them having their nationals judged by these courts. So the United States, putting it simplistically, says, we support the idea, we'll even pay for it, but we won't submit to its jurisdiction. So there is this conflict in the United States, and the pendulum swings from the worst situation looking at it from my perspective, in the first Bush 4 years when the administration, with the gleeful leadership of John Bolton, tried to kill the ICC in its infancy, to the second term of President George W. Bush, when they began to support the ICC, didn't veto the referral of the Sudan situation to the International Criminal Court. And in the last year of the Bush administration, I remember the legal advisor at the State Department saying publicly on a panel I was moderating in Washington, D.C., that they were in fact assisting the Chief Prosecutor of the International Criminal Court, and that assistance has obviously continued to an even greater degree in the Obama administration. What will happen after November is anybody's guess.
Very true. I wonder if we could stay for one question on the role of the Chief Prosecutor, whether it's for specialized tribunals or within the ICC. People have accused, or have because the Chief Prosecutor always becomes a figurehead. What should his or her role be in marshalling reluctant countries, in exercising his power, her power, internationally, in working both with supporters and those who are outside the framework? Is the role of the Chief Prosecutor in the ICC's case, is that adequate? Is he discharging that with a sufficient backing?
Well, again, there isn't a simple answer, but the main work of the prosecutor, of the Chief Prosecutor particularly, is to prosecute. The brief given to him or her is to investigate war crimes in situations subject to the jurisdiction of whichever court it is, whether it's one of the UN ad hoc courts or mixed tribunal or the International Criminal Court. that's the work of the prosecutor. And bear in mind, importantly, that the customers of international justice or any justice system are the victims. And it's important to bring acknowledgement to the victims. So that's the first and main brief. But it carries with it a necessity to be a diplomat, to get governments to go along, to get funding from whoever the funding body is, and to get the funding you have to demonstrate that you're worthy of getting the funding. I found it very useful in The Hague to have been adopted by the diplomatic corps. I got invited to all the diplomatic parties, and that was very useful, and I learned that diplomatic parties are very much working parties. When many problems I had were resolved over a drink at this or that country's national day, and that was very useful. And so the chief prosecutor has to be involved in the politics with a lowercase p. It's the politics of the tribunal, the politics of the UN in the case of the UN tribunal, the politics of the Assembly of States Parties in the case of the International Criminal Court. And then the chief prosecutor must be a good office manager, a good administrator. There has to be a happy office. There are all sorts of issues, such as sexual harassment in the office, in a prosecutor's office, an international office with a lot of police investigators. That's an issue I found very early on had to be handled firmly. And so there are all of these various areas. So one has to be, in some senses, a jack of all trades.
Turning our eye to Africa, before I get to Rwanda, I have one question particularly to that. I would be remiss if I didn't ask you about Charles Taylor and today's verdict.
Sorry, about?
Charles Taylor.
Right. Well, I think it's a huge victory for international criminal justice that Charles Taylor, former head of state of Liberia, has been found guilty on 11 counts of war crimes and crimes against humanity. Not on the basis the prosecutor would have wished, on the basis of direct participation, but on the basis of aiding and abetting. But I don't think, in the end, that's important. He's been found guilty of serious war crimes. I've little doubt he's going to get an adequate sentence in a few weeks from now. But already the press reports are coming through on the web of rejoicing in Sierra Leone. And of course that's what it's all about. They are the victims who suffered as a result of the direct encouragement and aid that Charles Taylor gave to the rebels who caused so much tragedy and injury and death in Sierra Leone, admittedly more than a decade ago. They regretted that it takes so long.
So my last question is around that issue, but with a particular look to Rwanda. So the ICTR's stated goal was to contribute to the process of national reconciliation in Rwanda and to the maintenance of peace in the region. You've talked a lot about the role of the prosecutor, investigate, but that seems to extend in some ways the mission that you just spoke about. So do you feel that conflicts with the court's role to prosecute violations of law of armed conflict and to provide justice to victims, or is that one and the same?
No, I think it's all part of the same, two sides of the same coin, and I think that the Rwanda Tribunal has aided in bringing about peace and reconciliation. One example, when we began in 1990, at the end of 1994, when the Rwanda Tribunal was set up, there were denials in Rwanda, in Europe, in France in particular, denial that genocide had been committed. This was spontaneous violence. What many disparagingly in Europe said, this is how Africans behave. One heard that sort of talk, but the evidence of hundreds of witnesses have proven beyond any question that this was a most carefully planned and brilliantly executed genocide, killing 800,000 people plus in 100 days, which is quite remarkable when you take into account that these were more or less eyeball-to-eyeball murders. They weren't using modern arms and ammunition to achieve it. And the result of that is an acceptance by everybody in the region, importantly Rwanda, but also in the outside Africa, a recognition that this happened. And that's important because I believe firmly, and I don't know anything to the contrary, that because of the work of the Rwanda Tribunal, the Rwanda government was able to implement its Gacaca system, that whatever criticisms one might have of it, succeeded in releasing from terrible prison conditions something like 140,000 people and being able to get on with their lives.
I want to thank you for your time. For the Future of Diplomacy Project, with the Future of Diplomacy Project, Justice Goldstone. Thank you very much.